Thank you, Mark. As Mark mentioned, my name is Grayson Chester. I'm an attorney at Reberg Law, where I've been for about the last 2 years now, very much enjoying doing estate planning full time. That is my passion. So as Mark mentioned, I'm going to be talking today about trust splits. And just to situate you here so you actually can follow along with me, this is what happens when the first of you passes away. At that moment, there's something to do for the survivor. The survivor needs to set up this family trust, this credit shelter trust, and they're doing this with the instructions that you leave for that survivor in your estate plan. Part of those instructions will dictate how the assets should be split, and there's a whole array of methods for accomplishing a trust split. We could teach an entire class. In fact, we could probably go for half a year on all of the different types of trust splits. I won't bore you with that today. I'm just going to talk about the two that you most commonly see today in Washington that typically have the most benefit for the most number of people. So with that in mind, let's talk about the first type of trust split that we typically see in estate plans, and this is the disclaimer trust. The disclaimer trust is effectively saying that you're going to give everything to the surviving spouse. So again, situate, this is the first option that Mark mentioned, all to spouse. But you're providing a little caveat there at the end, saying, in the event my surviving spouse disclaims, which is effectively saying, I don't want it. In that case, whatever the surviving spouse disclaims, whether it's $1 or all of the dollars or anything in between that would be passing to that surviving spouse, instead goes to the family trust. This is extremely flexible planning. You have no guarantee as to what is actually going to happen at the first spouse's death. And there's no guarantee that the surviving spouse makes the right choice, but it keeps a lot of options on the table. It's especially valuable when you only have a concern about estate tax. So if you have a blended family, if you have got concerns about his kids versus her kids, and there may be other creditors or predators out there, a disclaimer may not be the right option. But if the only concern is estate tax, and you're maybe not even sure at that point whether or not that concern will in fact happen at your death, you may be just above, just below, you're not quite certain. In that event, it's often a good idea to provide some flexibility. And in that case, as I said, we're saying give it all to the surviving spouse. But if at that time the surviving spouse realizes, hopefully after talking to an attorney, that there may be some estate tax consequences in the long run from doing it that way, then the surviving spouse would typically be given the advice from us to disclaim all or a part of what would be passing to that survivor otherwise. So again, there's a lot of power that you're putting into the survivor's hands here. And the survivor may not make the right choice, but the benefit of this is flexibility. And flexibility in modern estate planning is a very, very important tool to have. This is especially true for people who often don't update their estate plans more than once every 5, 10, 15 years. As we've seen, and Mark's mentioned as well, the estate tax exemptions have bounced around. Back in around 2000, it was only $650,000. So the idea of an estate tax was something a lot more people had to deal with at that time. Whereas nowadays, at least on the federal side, $11.4 million is probably not something very many people in this room have to worry about. There may be a few of you, but I'm willing to bet that the $11.4 million exemption is not troubling too many people right now. As Mark said, that is ripe to be changed. That may go down. So having that uncertainty about where this estate tax exemption may be can compel you to want to incorporate some flexibility into your plan. So if you're, say, otherwise okay with the concept of your spouse getting it all, and that's a very common plan in Washington. Yes, you want the survivor to be protected, of course. But you have this concern about estate taxes, along with this uncertainty about what that estate tax regime might look like at your death, then a disclaimer is a very good option, and it's a very powerful option. So let's talk a little bit about what a disclaimer actually is here, because I just mentioned this as the surviving spouse says, I don't want it. Well, it's a little bit different than that. A disclaimer has a couple of requirements to it. The first and most important one is that it has to be done within 9 months. That is a hard, fast deadline. And unlike something like, say, an estate or gift tax return, or really any tax return, the IRS is not going to grant you an extension on doing a disclaimer. You have 9 months to the day. And if that disclaimer is done the day after, it is no good, which means that there is a only 9-month window to do this. So if you think about it from the perspective of the surviving spouse dealing with an enormous amount of grief on one hand and also the burden of administering an estate on another, there really is a risk that this type of disclaimer would ever be done within 9 months. Now, if that surviving spouse gets good legal counsel shortly after the death, then obviously we would counsel the surviving spouse into making that type of disclaimer if it were truly the best thing to do. But there's some risk that the survivor is overwhelmed by the burdens that have been placed on them as well as their own grief. And so maybe this disclaimer might not actually happen. That uncertainty is the cost of flexibility. So with that in mind, let's talk about another type of trust split here, and this is the 50-50 trust split. Intuitively, this is the type of trust split that typically most people conceive of. His is his, hers is hers, theirs is split 50-50. So in legal terms, the separate property stays separate, and the community property is split down the middle. This is a very, very easy to administer plan, and it's one that you can typically explain to the survivor will understand it, for lack of a better word. It's usually pretty easy to comprehend. There's a small danger, however, and this would only come up if your combined assets are over 2 exemption amounts. That splitting everything 50-50, his is his, hers is hers, theirs is theirs, causes an estate tax at the first death. I'm sure some of you probably thought of this at the very beginning here. If, let's say, you had $6 million of assets, and $3 million is going to be attributed to the first spouse to pass away, and the Washington exemption now is just a little over $2 million, that's a tax on that extra $1 million, and we don't want that, of course. So that's the cost of 50-50, and there's a way to avoid that tax. That tax can be avoided with something called the Q-tip, and this is exactly what Mark was alluding to. The benefit of a Q-tip is that you can pretty much guarantee with quite a bit of regularity that so long as this election is actually made on an estate tax return, there is no tax at first death. Whether you're leaving the surviving spouse just under the exemption amount or whether you're leaving the surviving spouse $100 million. So long as it qualifies for this unlimited marital deduction, which is exactly the purpose of the Q-tip, there will be no tax at the first death. So the cost here, if you want to conceive of it within a 50-50 plan, is that you need the Q-tip element, the ability to qualify for this marital deduction in order to avoid estate tax at the first death. So let's talk about what a Q-tip actually looks like, the requirements so that the trust that you're setting up for the survivor will meet all of these burdens in order to guarantee that there will be no estate tax with a 50-50 split. So a Q-tip is actually deceptively straightforward as far as the requirements go. All of the income of this trust must, not may, must be payable to the surviving spouse. Intuitively, that makes sense. If we want to take care of the surviving spouse, obviously we want there to be some type of income stream taking care of the surviving spouse. That's usually not a big hang-up here. The second requirement here for a Q-tip is that income stream, the income that the assets in this trust produce, has to be paid out to the survivor at least annually. If this is something that the trustee can withhold, has any discretion to withhold for any longer than 1 year, it just categorically will not qualify. The third and final requirement, and this is the one that you usually can't just find, the great 2 or 3 words in the document that says whether or not it meets. The third final requirement is no one else can benefit from this trust in any conceivable way until the survivor has passed away. Makes sense, right? If this trust is going to qualify for the unlimited marital deduction, it better darn well take care of the surviving spouse and not someone else. This means a 50-50 split needs to take care of the spouse first, and then your other beneficiaries after that. That is the cost of this Q-tip planning in part as an element of the 50-50 split in order to avoid the estate tax. So those are the 2 major types of trust splits that we see in documents that tend to have the best possible result for the most number of people. So let's now move on to the choice of the assets that we're actually going to use to fund the credit shelter trust. At the moment of death, I'm sorry, there's a question here. Go ahead.
Sorry. Who becomes a trustee of a Q-tip trust?
whoever you want. It's usually the surviving spouse, though. Usually the surviving spouse is in charge of administering this trust for their own benefit. Thank you. And to be clear for the camera, the question was who is in charge of administering this trust. In your document, you can name the trustee, and usually, not always, but usually the trustee of this trust created for the survivor is in fact the survivor themselves. Another question here?
Does that mean that you can't help a grandchild with educational money or anything?
That's exactly what that means, yes. Now, there are ways to accomplish that. It just, that money that you may have earmarked for someone other than the surviving spouse would have to pull from your exemption. And that means that's less money that you can protect from tax at the survivor's death. So there's a cost for doing that. It can be done, but generally speaking, in this type of planning, especially if you're doing a 50-50 and qualifying it for a Q-tip, it needs to provide for the survivor, and then it needs to take care of your other beneficiaries in that order. It can't be happening simultaneously. I have another question?
The income flows to the surviving spouse. What prohibitions on it after the spouse has it?
I'm sorry, could you reword that?
The income flows to the surviving spouse, so you got it.
Mm-hmm.
Are there any prohibitions about what they can do with it?
So the question is about any prohibitions on the surviving spouse's access to that income, or rather I should say use of the income stream provided to that surviving spouse. No, there can be no requirements that the income be used for a certain purpose. The income must go out to the surviving spouse and they can use that for any purpose. That, however, the principal, the corpus, the portion of this trust producing that income is typically protected. The purpose of that is to make sure that you do in fact have a pot of money there in that trust to pass on to your beneficiaries after the survivor has passed away. Now, this is not an either-or type of thing. The survivor can access, in most cases, the survivor is allowed to access that big pot of money producing this income, but there's a limitation on their ability to access it. We call this the MESH standard, or sometimes we'll rearrange the letters depending on who you're talking to, the HEMS standard. And this is an abbreviation. Maintenance, education, support, and health. So if the surviving spouse needs to access this money to maintain their normal standard of living, to provide any potential education opportunities for them, any health issues that come up, they can absolutely do that. But that is a limit. They can't simply take out that money and go blow it all in Vegas or give it to Julio the pool boy. There is an ascertainable standard, and this is just a term from the IRS, that prevents the surviving spouse from accessing that money to the extent that that money would be treated as theirs. And that is a big portion of the estate tax protection, is artificially, and from tax law perspective, that money is not theirs. They can access it for certain purposes, but tax-wise, it is not theirs. So that answers your question about both income and principal. Any other questions before I move on to the choice of assets?
What does CST mean?
Credit Shelter Trust. Unfortunately, I did not have enough room in the PowerPoint to spell out Credit Shelter Trust, so I'm sometimes using the abbreviation CST. So the question here, I should say, the fear is that if we name the survivor, the person who's in control of making these distributions, what stops the survivor from doing something unethical or perhaps illegal even with that money? Something where let's say they make a large deposit from the trust into their own name for a completely impermissible purpose. Jim is going to touch on that a little bit here, but the real answer to that question, if that's a concern, if you are afraid the surviving spouse might do that, don't name them as trustee. That's going to be a very individual choice here. In most cases, we do trust our spouse, and the spouse understands the purpose of this trust. That's not always the case, and it's perfectly legitimate that you are going to name another trustee to administer this trust for that survivor's benefit. Any other questions? Okay, let's move on to the choice of assets here. So let's take the simple 50-50 split. The 50-50 split does not mean that 50% of every single asset has to be divided down the middle and retitled. What it means is the entire lump sum pot is divided by value 50-50. So that means 100% of one asset can be on this side and 100% of another asset can be on this side. This is actually Washington law, this is the default, but we put it in the documents as well just to be clear. you do not actually have to go through every single asset and split it down the middle. That would be an absurd result. So that means that there is actually a little bit of gamesmanship to play here. Which asset do you want where? And this brings up a whole slew of considerations, including something called the step up in basis. The step up in basis is something that happens at death, and this is a step up in tax basis. So just very brief summary of what basis is. If you buy property for $500 and you sell it for $1,000, we need to know how much taxable gain there is. The basis of that property was $500. You sold it for $1,000, and now there's $500 of gain. So the basis here is $500. The gain is $500. Knowing what your basis is the cornerstone of understanding what a tax burden is. At death, we get an unlimited step up in basis on all of our assets. So we've got typically our homes or our stocks or anything of that nature has a pent up tax burden in it. It's unrealized. This is, I purchased my house for $400,000 10 years ago, and it's now appreciated up to $750,000. Well, there's $350,000 of gain there. At death, that gain, that pent up gain that is unrealized and should be taxed, disappears. If it is going to be taxed to the survivor, it will get a step up. If it's not going to be taxed to the survivor, it will not get a step up. Now, to be clear, we're talking about the second step up at the survivor's death. If you have it in your name at the first spouse's death, it's going to get a step up. But one of the benefits of being in a community property state is that you tend to get a second step up. The first spouse dies with all of the assets, and the second spouse dies with all of the assets. So the choice then of whether or not this asset should get a second step up has a lot to do with predictions of how much that asset is going to grow and how much tax burden we're trying to save, income tax burden we're trying to save for the ultimate beneficiaries down the line. So with that in mind, one of the assets that is typically not funded into the family trust but is left to the survivor is usually the house. In Washington, home prices have gone up tremendously and really are not showing too much signs of slowing down. We've got a very good real estate market, and we have for a long, long time. That means that we typically don't want to put this in a trust that's not going to be taxed to the survivor. We want to take advantage of the first step up, of course, but we also want to take advantage of the second step up at the survivor's death as well. So that's part of the calculus here, playing which assets should go where. So the home is a great example of an asset that traditionally, not always, but traditionally is going to be left to the survivor. And the survivor's, let's say, community property interest in that home will go to the family trust in the form of another asset. So let's say that home was owned, community property, each spouse had about 50% interest in it. Well, if it's all going to the survivor's own 50% interest will be going to the credit shelter trust in the form of some other asset, stocks, bonds, maybe another piece of real property. Something else. It doesn't have to be the same piece of property split 50-50 and put on either side. Does that make sense? Any questions about that before I move on? Okay. The final subject I want to talk about here are some of the common problems we see with administering trust splits. Go ahead.
Your slide says you're talking about qualified accounts.
Oh, that's true. I did miss that. So this is its own separate type of topic here. I put that in the slides here just to mention the value of a qualified account, like an IRA, can be used. Notice I said value, not the account. Can be used to make up some of that funding. And a trust, though, typically cannot be the owner of an IRA. It's the individual. So we play games with the community property interest between the survivor and the decedent to end up attributing more assets than would maybe otherwise go to that family trust because the survivor is getting the IRA outright in most plans. So that's just kind of a little quirk here I wanted to throw in because people do often ask about IRAs involved in trust splits, or 401ks as it were. And so I wanted to point out to you that yes, there are things we can do with these IRAs in order to fund more or less into the actual family trust, credit shelter trust. Good catch. Okay, so let's talk about some of the common problems here with administering trust splits. And so I put 3 big ones that we see on a regular basis here. The first is older documents tend to have older trust splits. That's something we should just understand, is that the document that we created back in 2000 probably has a 2000s level understanding of law and estate tax and everything else that comes along with that. Because there's been a tremendous amount of change in the availability of certain elections like Q-tip, but also portability, which Mark hinted on earlier. This is the ability to leave any unused exemption amount from the first spouse to the survivor spouse to add to their own. There's been a tremendous amount of change here in the law, and so these older documents often don't have trust splits in them that really accomplish what they would have accomplished had you died back before the law changed. So there's a whole slew of people going about their lives with these trust splits in their documents that don't really make much sense anymore. And oftentimes they're incredibly complicated because at that time, the estate tax protection could only really be accomplished through very complicated estate trust splits, including one that we hear all the time sometimes, called the ABC split. We very rarely use that anymore, but that used to be one of the absolute best possible ways of accomplishing all of your estate planning goals with as little tax as possible back about 15, 20 years ago. So there's a danger now if you were to pass away with that type of document. Well, you just made the survivor have to read through this terrible, terrible language here. Those trust splits are quite brutal to read. But two, that may just not be what was actually best now that you passed away 15, 20 years after you put this in your document. So it's very important to get those things checked out by an attorney. I will say that the modern practice now of creating Q-tip eligibility normally solves most of these concerns that we weren't quite able to address the same way back 15 or 20 years ago. So the idea that this would change in the future is much less of a risk now than it was back in around the year 2000. So hopefully this is a one-time thing, not something that we're just going to have to keep changing our minds on as the law changes. There's no guarantee. Another type of problem that we see often is when the first spouse passes away, the survivor doesn't do anything. Sometimes the survivor sits on their hands for a year, or 5 years, or 10 years, and eventually makes their way to an attorney. And the attorney sees this document and says, you know, there's supposed to be a trust split here? Something's supposed to be done. And the survivor says, oh yeah, but it's been so long, that surely that doesn't matter anymore. Surprise, it does matter. The survivor is a fiduciary under this estate plan, presumably, if they're going to be named as trustee or executor. And they have a duty to administer this credit shelter trust for their own benefit, of course, but more importantly, for the beneficiaries after that surviving spouse has passed away. The surviving spouse intuitively should not typically have the right to change the beneficiaries of this credit shelter trust set up by the decedent. It's provided for that surviving spouse's benefit, and that decedent's wishes will continue after the survivor has passed away. The survivor does have to administer this trust. Simply because time has passed is not a good reason to not do what you are legally required to do. And so this problem has actually been a pretty thorny one in recent times, where you end up in situations where nothing happened for over a decade. Now, the easy answer for what you're supposed to do here is that you're supposed to do a good faith effort to split the assets as they should have been split at that time. That time, again, could be a decade ago. It's difficult to do and something that you should absolutely get professional advice, because at the time, 10 years after the fact, you're in a much better position to attribute the subsequent gain or loss of those assets where it should have gone, as opposed to doing it at the time of death. So the IRS is very wary of someone waiting for 10 years to do this and picking the best possible option at that time. It needs to be a fair assessment at the time of the first spouse's death, not 10 years down the road when you already saw what happened. And then finally, another thing that I'd like to talk about as a common problem with trust splits is that, and I've hinted on this before, Q-tip eligibility was not something that people thought about too much back, 15, 20, 30 years ago. Nowadays, that is the modern estate planning approach, is to create trusts that qualify for this Q-tip election to make sure there's no estate tax at that first death. The benefit of doing that is ultimately it solves a whole heck of a lot of problems, just because having the ability to make that election is an enormously powerful tool. It's often not a compulsion. It's not something the surviving spouse has to do, but just having that tool in the arsenal at the first spouse's death is something we call post-mortem estate planning. the idea of actually being able to game the system a little bit after the first spouse's death, and being able to accomplish the best possible result then by giving the survivor the most tools to use. So older documents often don't have that option. They often will not qualify for the Q-tip, meaning, let's say they peg it to the federal exemption amount, which now is $11.6 million, and they put that all into the family shelter trust. Washington, again, state tax of the exemption is a little over $2 million, is going to charge a tax on $9 million of assets simply because this trust didn't have the required provisions in it. That's a bad result, and that's something that can be solved as simply as looking at your own documents and getting them updated if they're not Q-tippable.